benefit of our clients, even though it's wrong, you ought to assert it. You may be immune from liability if you research it and you exercise your judgment and find it and make a wrong call, but you could very well still be subject to liability, even though you were ultimately correct, like the lawyer in Mass. So the news for 1986 is we can be sued for correct decisions. Moving into the area of attorney's fees, the Renfrew case, which is number 34 in the supplement, is the good news for attorneys and attorney's fees. This was a dispute between an attorney and a client. The attorney represented herself in pro per, sued for fees, recovered fees, and then sued for attorney's fees to recover the fees. And the Court of Appeals held that the lawyer could recover fees under Section 1717 because there was a prevailing party provision within your contract. This will make the legislature real happy because I know there's a case on the books that says that a non-lawyer suing for the time incurred in improper cause of action can't recover. So lawyers can recover, non-lawyers can't recover. This is time for the annual admonition regarding a fight over fees. 1/3 of all cases, all malpractice cases, arise out of a complaint for fees. So you can recover in pro per, but you know you have to consider the ramifications of going forward with that fee action. I mentioned when I talked about ROA, there was a significant case that talked about whether or not you can increase your fees above the MICRA Section 6146 limitation on contingency fees in the medical malpractice area. The Waters case, that is number 15 on your supplement, is the Supreme Court decision dealing with the situation where the plaintiff sued the psychiatrist for fraud, battery, and professional negligence. And the question was whether or not in this combined lawsuit, the fraud and battery being non-MICRA causes of action, and the professional negligence case, cause of action being obviously a MICRA cause of action with the fee limitation, whether or not the lawyer could take a fee in excess of the MICRA statute. The Supreme Court indicated that you could under certain circumstances and with the proper disclosure to your client. If you're in this area and you have a hybrid cause of action, I commend the Waters case to you. You ought to read it very carefully because I think it's a troubling decision. I think that it places a plaintiff's lawyer in a bit of a conflict when they start to represent a client knowing that they could recover fees, additional fees under one cause of action and lesser fees under another, and the fact may very well be you could lose insurance coverage by asserting the non-MICRA causes of action, the intentional causes of action. I think it's a can of worms. You can do it. You ought to look at Walters to see when you can get away with it. I'm going to briefly run through the CCP 128.5 cases. The first thing that you should know about, though, is that there's a new amendment to the statute. It's now okay to assert a CCP section 128.5 motion for fees when you have a frivolous action, as opposed to just a motion or some antic that went on in the lawsuit. A frivolous action can be subject to 128.5 sanctions. The mere filing of a complaint and the fact that you didn't serve it would not be included within this mere action right to sue. That's excluded from the new amendment that's on page 79 of your material. Lesser versus Huntington Harbor Corp., that's number 35 on your supplement, is a Court of Appeal decision that basically follows the statute. Prior to the enactment of the statute, Lesser says you can recover fees. I think this is a motion that you can bring that would be an alternative to a malicious prosecution action and probably a quick and easier way to go about this. I think we've had enough cases on the subject of what gets you in trouble, and I think the Supreme Court agrees with us. So cross out the Swigert case on page 69 because that's been decertified. Robert?
Thank you, Joe. All right, ladies and gentlemen, I want to tell you 9 more things, and I'm going to do it in 3 minutes or less. Still on the subject of attorney's fees, at page 73 of your course materials, the case entitled Manier versus Anaheim Business Centers, deals with the question of when attorney's fees can be recovered in an action involving a contract which has an attorney's fees clause, but in which the trial court finds that the contract is not enforceable or in fact was never a contract. This is a real estate deposit receipt case. The court finds that there never was the necessary meeting of the minds, and therefore the essential elements of the contract formation process were never completed. And nonetheless, the court does award attorney's fees to the prevailing party under Civil Code Section 1717 as a provision of contract-based attorney's fees in a non-contract. I want to bring a case to your attention which is so hot off the press, it's not even on your supplement list. It's in the February 12th edition of the Daily Journal, the case entitled Lany, L-A-N-Y-I versus Goldblum, and its citation is 86 Daily Journal 482. This case crosses over between 998 offers and attorney's fees under CC Section 1717. Briefly, a plaintiff sues a defendant, again in a real estate case, on a contract that has an attorney's fees clause. The defendant makes a 998 offer, which is silent on the subject of attorney's fees. The plaintiff accepts the offer. The acceptance is silent on the subject of attorney's fees. Judgment is entered pursuant to the accepted 998 offer. The plaintiff then applies for attorney's fees as costs pursuant to Section 1717. The Court of Appeal holds, even though the offer was silent on the subject, or because the offer was silent on the subject, the plaintiff is still entitled to recover attorney's fees. I suggest to you all run back to your offices tonight, find out if you have any 998 offers that are outstanding that are silent on the subject of attorney's fees. If you're at the short end of that proposition, you better withdraw or amend your offer before somebody on the adverse side accepts it and gets attorney's fees as well as what you intended to offer. Malwerman Integrated Circuits Consortium, which is identified as item number 36 on the supplemental list, deals with the situation in which a party is allowed to communicate with the former employee of an adverse party. Deals with the question of what is a proper or improper communication. The course materials indicate that there are no matters of significance in family law. We want to give you a different point of view on that. Marriage of Buell, which is cited as item number 37 in your course materials, is a landmark case holding unconstitutional a provision of the Family Law Act, which reversed the former law under Marriage of Lucas. Marriage of Buell holds that it is unconstitutional as to at least those cases which were pending when the statute went into effect, to require that there be a writing determining whether a interest in residential real property is separate or community in nature. Marriage of Lucas had held that a party could establish an understanding or agreement which could contravene the record state of title. The new statute reversed that. Marriage of Buell now says that that's unconstitutional. California Rules of Court 1285.15 and the provisions of Civil Code Section 4700.2 implement a new procedure that allows you, following a marital dissolution judgment, not more frequently than annually, to serve a request or a demand for an income and expense declaration without actually filing a support modification motion, the purpose being to allow you to determine whether the game is worth the candle, whether there's been a sufficient change in financial circumstances to actually justify filing a motion. And although the case materials say there are no developments, if you look at page 119 of the course materials, you'll find the Judicial Council form that authorizes that procedure.